This is inconvenient Friday at 9 o'clock, and but we want to accommodate our Atmiya members, global members, community members from India, Europe, Middle East, East Asia, and UK, Canada. Atmiya is a global organization. We have the groups across the world. So a lot of people might want to migrate from Australia, New Zealand, Europe, and everything. That's why we have to do a common time. Thank you very much, and really appreciate you all joining the call, Atmiya Immigration Call. This is February call. This is second session on the H1B immigration. And all this possible. Atmiya is atmiyausa.org. All this possible. The idea of the Atmiya is to empower our community financially in this great country. America is a land of opportunities. We are here for 20 years, people migrating, but we haven't seen any change in our community compared to other communities. Hardly you can count on the entrepreneurs. What is the entrepreneurs? More than $10 million balance sheet. To the real estate investments, stock market investments, to the, it's become a CEO, CTO, or something. Nothing is happening, and not much. Of course, they are there, but you can count, hardly count. But with what we want is we want to transform our community. Our community need some kind of more education, how we can take on risks, how we can take get an education, how we can grow in this great country, which gives equal opportunity for everyone. With that philosophy, Atmiya started. Atmiya has the first elected body this year in 2024, and Vijay Ramsetti, our president, and secretary Ramesh Nainala. And we have the 9 chapters, 9 chapter president, 9 BODs, and his state volunteers, the fabric services, fire, best, immigration, asara, births and real women, and community affairs. We have all the chairs. We have all the, 9 service coordinators for each chapter. Imagine you have a 120 executives, all these volunteers working hard and sacrificing their personal time to, educate our community, educate, empower, enrich, and elevate our community. So we are requesting everyone to take a Atmiya donor membership. And I'm telling you, today we are at 2,000 members, 2,000 plus members. We want to make 5,000 members by end of the year, or 10,000 members. Actually, we want to make 10,000 by end of the year. It's all possible with your references, with you taking the membership. It can be a global people can take, other than US, they can take the community membership. Other people can take a donor membership. With that note, I would like to, the immigration team has 9 chapters, 9 directors. We have the great immigration team. We are going to do no other NPO has done this, is going to do this kind of revolutionary initiatives. Take my word, under the new leadership and the new volunteers, we are going to do the, best initiatives which empower the NRI community, especially Atmiya community. With that note, I want to introduce our immigration team. Bhanu garu, welcome to the call. And sorry about that. Just I'm introducing Venkata. Can you go to the next slide, please?
Yeah, sure, Andy.
Here is the new team for 2024, the immigration team. First of all, I want to thank Bhanu Ilindra garu for joining the call. And I think Chaitanya Setti is a vice chair for Atmiya Immigration Service. And Venkati Chaitanya is the youngest entrepreneur. He is running the OpalSoft, and he is going to, introduce the Bhanu garu later. And Venkati from the capital region, and he owns the company, and he is going to moderate the agenda for today's call. And we have the best team. The best means business, engineering, science, and technology. Hari Kurgala is the best safe. And we have the best director from Empire region, Rajapursu. They're here. Next, I want to introduce the immigration team, new immigration team. These are the volunteers across 9 chapters. Venkata, go to the next one. Yeah, I think the next one. You can go to the agenda, you can go to later. Next one. Next one. Yeah, here is the team. Chaitanya Setti, Vice Chair, Karthik Siddhabatani from Capital Region. He is Immigration Director. Kishore Kugilapu, North Texas. Maurya Edavalli, Northwest, the Bay Area and Seattle. Sacha Dasri, Northwest Chapter. There is a confusion. Sorry, Southwest, Sacha Edavalli. Sunil Jinala is Central Region. Next one. Next one. Venkat Imani from Capital Chapter, Venkat Raj Kotari from South Texas, Srinivasu Ramsetti from Southeast. I think, Harini Kode, she is a wonderful volunteer for last 3 years. She has been serving the Atmiya community for last 3 years. To this year, I think, that picture is missing. With that note, I want to congratulate all the immigration coordinators and vice chairs. And I will be the advisor. And this team is going to run the entire show for next year. I want to congratulate, welcome all. With that note, I want to hand over to Chaitanya to introduce Bhanu garu. Thank you.
Hi, good evening and good morning, everyone. Bhanu Garu is one of the senior most lawyer based out of Herndon, Virginia, and he currently owns a BBL law firm, and he's also a very active member with IT Serve. He's actually the diamond sponsor for IT Serve this year. And with that, we welcome Bhanu Garu. And for any kind of questions, he has been a pioneer for us.
In 5 feet, turn right onto Maple Way, then bear left towards Main Street.
He has been a pioneer for all the immigration matters, and we welcome you, sir.
Thank you. Thank you very much, sir. Can you all hear me, Andy?
Yes,
Hello?
Andy. Yes.
Yes.
Yeah, Bhanu garu here, Venkat Imani, he's our neighbor in the Virginia. He's going to
Yes.
coordinate the agenda for this. He and Chaitanya will coordinate the agenda for today's.
Sure.
Venkat Imani, back to you. Chaitanya, Bhanu
Okay,
garu.
thank you, Omgaru. Thank you for everybody. Welcome, Baru Garu.
Thank you,
This is
Venkat
second
garu.
session.
Good to see you, Andy.
Second section. Yeah. Yeah. I don't need to introduce any further. Bhanu Garu is everybody knows here and across the USA. Whomever in this business, employers and applicants as well. So when coming to the agenda, so what are the first thing? Please register. Take in that link. Please, employers and beneficiaries, please register the link which we provided on this player. And the second thing, please register, be a member of the Atmiya, and you will get a lot of benefits, as Omgar said. And second thing, what are the do's and don't do's of the employers first, and after that employees. The second thing, maybe it is not in here, but second thing is what are the changes last year and the current year, between what are the changes in this new registration process. And the second, third thing is what are the MSA and SOW projects and products that as an employer we have to be make it ready, and what are the things that we have to be mainly focus when during this immigration process. And the last question, last thing is know your employer or sponsor and each other, applicant and employer. You have to have make a documentation connection. It's having interviews and make that as a document to prove that you are you reached the employer directly. That kind of things that going to be covered in Bhanu Garu. Bhanu Garu, floor is yours.
Thank you, Venkat garu. First of all,
Bhanu garu, before you go to sorry, Venkat garu, for the Venkat Imani garu, Rajbursu garu from Best and Bhanu garu, we have Atmiya has the fabric services. Venkat garu, Chaitanya, and all this team we introduce is the representative immigration team. We have the best team, business and engineering, science and technology, who represent the 500 employers in Atmiya. Rajbursu garu, you want to talk about Atmiya employers? Almost 51 employers registered with Atmiya. Rajbursu garu, please, Rajbursu garu, And Hari Kurgagar, please.
Sure, Andy.
10
Yeah.
seconds, yeah.
Hi, everyone who joined this call. I extend my heartfelt gratitude to all the employers who participated in this exceptional immigration call hosted by Atmiya with the collaboration of Immigration and Best team. We gather here to acknowledge and celebrate the significance of Atmiya, a non-profit NPO organization that stands as a remarkable platform for everyone, for employers, employees, and job seekers within our community. Yeah, thank you so much, each and everyone who joined this call. Yeah, we are going to make a beautiful event today. Thank you so much.
Bhanu garu, back to you. Bhanu garu and Venkatiman garu, back to you. Sorry. Yeah, thank you.
Thank you, Om Garu. Thank you, Raj Garu. That was wonderful hearing from you. And thank you, Om Garu. Thank everybody in the immigration group, Andi. Everybody, I mean, I'm sorry, I'm not able to put everybody's names here. Venkat Garu, Raj Garu, and Chaitanya Sitti Garu, everybody, along with Om Garu, and all the entire Atmiya members for conducting this event, this conference call, especially at this time. It's very, very important for us to understand what's going on with H1B registrations, CAP cases, and what are the proposed changes or what are the changes likelihood will happen with the H1B program, and how we can strategize as an employer and as well as an employee, and how we can pursue our dream and our goal and our career. And that's why this call is very, very important. And a very timely call too. And really appreciate all of you Friday evening coming and joining to this call. That shows how serious you all are to understand what's going on with immigration laws and everything. And I sincerely thank you for giving this opportunity for me. Always Om Garu always ask me to come and join your call, and really appreciate that. And I'm glad that I'm able to connect with the Atmiya family in this way and able to provide all the updates, whatever I can, to the Atmiya family. Before going into the discussions, what the immigration laws are and everything, I just want to detail you all is to provide this call is meant to provide you as accurate information as possible pertaining to the immigration laws and its updates. However, anything discussed in this call does not constitute a legal advice or create any attorney-client relationship. And also, anything discussed in this call or presented in this call is not protected in the attorney-client privilege because of that reason. Therefore, during Q&A or any other time, if anybody has any questions, try to keep it as generic as possible so that your confidential information is not compromised. Now, let's go to the real discussion. The first agenda item, which is H1B CAP registration for employers and beneficiaries. It's very, very important for us to understand a little bit of history before we go into the changes, what have been implemented this year and how it's going to impact lottery selection and everything for the H1B petitions that are going to be filed for the fiscal year 2025. First, we have to understand how the lottery system was done in the beginning for the past 4 years. Actually, in the 1 year, they did not conduct, but they conduct only for 3 years. And this year, how it's going to be done. That's very, very important for us to understand. In the previous years, the H1B lottery system was mainly employer-centric. That means every registration submitted by the employer for the H1B CAP petitions for the lottery selections, all those registrations have been entered as a separate and a unique entry for the lottery choice. Like how you're putting a chits for the lottery. If you take a lottery through chits, you write a chit, that every chit is considered to be one separate entry for the lottery, and you pick up one of those chits and see who got winner, who's jackpot winner, and all these things. Same way, that's how the lottery system used to be before. Every employer who submits the registration, that becomes an entry for the lottery selection process, and all of those entered, and then the algorithm is ran, and then randomly people are selected. Because of that, sometimes multiple registrations have been selected for same individual, which were not unused for the CAP season. During that CAP season, again, they had to go with the second lottery and third lottery. And also many people did not get an opportunity to get selected in the lottery, so they have to leave the country because their employers were not able to file H1B petitions and everything due to this multiple selections. This is more of a multiple selection rather than a multiple registration issue. That's what I want to let you know in this. and possibility of individuals getting selected in the lottery. That is what I'm talking about here. Of course, multiple registration that did contribute to that, but that's a different issue which we will discuss. But mainly, I'm discussing about the possibility of getting selected into the lottery. And because of that, what happened is USCIS felt, and also in addition to that, added with multiple registration, duplicate registration, and willful misrepresentation, willful misuse of CAP registrations and everything with excessive filings. So USCIS felt like in order to increase the chances of the individuals getting selected in the lottery, different unique individuals getting selected in the lottery, we will make it as a beneficiary-centric lottery system rather than the employer-centric lottery system. What does that mean is, if every employer submits a registration on behalf of one employee, which is an ex-employee, let's assume that employee is John Doe, okay? If every employer submits a registration on behalf of a John Doe, and the information of the John Doe is submitted to the registration by paying $10 by these employers, let's assume that 10 employers actually submit a registration on behalf of John Doe. What US is going to do is they're going to pick up the John Doe information, and that is going to be entered into the algorithm that does the lottery, that actually selects the lottery. That means all these 10 entries does not matter. They all considered to be one single entry for the purpose of lottery selection in the current lottery processing, which is going to happen. So only John Doe will be entered into the lottery system, not employer A, employer B, employer C, or employer D, like how it happened in the past. Okay, so in that way, there are more John Does will have an opportunity to get selected in the lottery because they are being entered into the system. Therefore, what's happening with that is it is actually de-incentivizing the employees to go with the multiple employers and seek an opportunity from them to file an H1B lottery registration. Because it doesn't matter if they get selected, they can go with any employer they want to who submitted the registration. So now, and the reason why they used to go with the multiple employers before is to increase the chances of getting selected in the lottery. Now it's not. It's only 1:1 anyway. It all depends upon how many. For example, if you have 788,000, if you submit 10 times, your ratio was 10 by 788,000 before. Now it doesn't matter if you get 788,000 registration. It is 1 by 788,000 no matter what, because there are 788,000 unique individuals are being entered into the lottery rather than the multiple entry or duplicate entry by these employers for the purpose of selection of a lottery. So your choice is, that's where what happens is because of that, the USS believes that number of individuals who get selected in the lottery will significantly increase this year, especially for the master's quota individuals, rather than what it has been in the past. And also they believe that because of that, it's de-incentivizes the employees to approach multiple employers. These duplicate registrations or collusion of colluded registrations and all these things will not happen, will not occur, or at least will reduce to the number, not what it has been behind and everything. That is the major change which they're implemented in the new algorithm. And that is where, that is what the lottery system is going to be. If anybody has any questions on all these things, I'm very happy to answer during Q&A to give the clarity on this issue. That is one of the major changes. Second major change in the lottery registration is you have to register an organizational account through the myuscis.gov account. You have a myuscis.gov account basically already to submit the registrations, but now you have to register as an employer on an organizational account to submit the lottery registrations, as well as to do any online filings tomorrow in the future, like H1Bs or I-140s or any other online filing you want to do. You can only do it through these organizational accounts. They have not implemented these organizational accounts before. This is a new one, and every employer is required to register for the organizational accounts, which is with the USCIS, going to the USCIS website. And these organizational accounts are going to open for the public to register from February 28, 2024 onwards. It's important to understand from February 28, 2024 onwards. So that is very, very important for you all to understand. And after registering with organizational accounts, then you'll be able to submit the lottery registrations for your employees from that account and pay the $10 fee and enter into the lottery and get selected in the lottery. So Keep in mind, if you think that you already have an account, forget about it. You have to re-register the account, and these accounts are going to open only from February 28, 24 onwards. After that, they're always available. You should be able to register anytime you want to, but it's always better to register as early as possible, because if any system glitches happens or anything happens, and if you don't have time to get them corrected, because the window for the CAP registration is only 2 weeks. That is from March 6, 2024 onwards, from to March 22nd, 2024 only. It's 2 weeks because there are 4 holidays in between, or 5, that's why. It starts on noon of March 6, 2024, H1B registration, and ends on noon of March 22nd, 2024. So keep that in mind, and you have to submit you have to get the organizational accounts open from February 28th onwards. You have 8 days time to open the accounts, to submit the registrations from March 6, 2024 noon onwards. So these are the changes which you all remember. These are the important changes with the systems, with the system accessibility, with the system registration, and with the preparing the or entering the lottery registrations. This is very, very important. You have to understand and you have to go with it. And one more most important thing which you all have to understand is that the fee for H1B CAP registration for this year has not increased. It is still $10. The new fee hike that have been, the regulations that have been passed will come into effect only after April 1, 2024. Therefore, the fee hike for the lottery registration will only come into effect from next year, from fiscal year 2026. And that amount will be $215. But today, as of today, it's only $10. And one more final important aspect of this registration is the information that you need to submit for the lottery registration have been slightly changed than what it was before. Before, you have to provide a minimal information about the employer and the employee to successfully submit a lottery registration in the system. Now, besides that minimal information, now they made it mandatory for you to provide the information of the passport or a travel document of the beneficiary, and also along with that, a proof of passport or a travel document by uploading the biographic pages of their passport or a travel document into the system. For each and every individual, you are submitting the lottery registration. So this is the major change that is happening with the H1B CAP registration this year. You have to provide minimal information about the company, employer, and the beneficiary. Along with that, you have to submit the passport identification number, and you have to upload valid passport biographic pages. Because most of the Indians don't have travel documents, therefore it's not applicable for us. That's why I'm only using the word passport. Because passport is a valid travel document, and that's why we are all required to have a passport to travel to US, and that is the information you have to enter into the system. Of course, some people worried about that. I only have a passport validity for 3 months, and my passport gets expired by the time I file an H1B if it gets selected. Will it be okay? It is absolutely okay. You submit the registration proof of the valid passport at that time, and if you get selected in the lottery, and if your passport expires after that, when you get a new passport, you're going to submit the new passport and the old passport and all the information together at the time of filing of an H1B petition with the USCIS. So keep that in mind. And also, do not commit any typographic error or a clerical error while you're submitting the registrations. If you do that, please consider that your registration will not be selected, will be declined or denied in the system right away once the lottery is done. Because if they see the discrepancy in the information you provided and the information available in the passport pages, they're going to deny that registration. Keep that in mind. So make sure that you all do multiple review of the registration information and accordingly submit. And also, good thing about this new system is if you are submitting a duplicate registration for the same beneficiary from your system, from your account, it is going to notify you. It's going to identify you. For example, as an employer A, if I submitted already registration for John Doe, and I forgot about it because I'm submitting for hundreds of people registrations in the lottery, and I'm going to submit one mistakenly, I'm entering that data again for John Doe in the system, previous
Okay.
years, there was no
Okay.
notification is to give to us that you're doing a duplicate registration or duplicate submission. But now it's going to tell you that as an employer, you already submitted the registration for this individual. Are you going to submit the duplicate one again? So that warning, that notification will allow you not to mistakenly submit duplicate registrations for the same individual and accordingly do not get disqualified for that individual to get selected in the lottery. So these are the important changes which they have implemented from this year. And I think the purpose of that is as they're claiming is to decrease the multiple registration and also increase the chances of particular individual. But in reality, it's all about money for the USCIS. USCIS doesn't care how many employers submit the registrations for the employees. They want to make that money. They want to get all that money. Reason for that is they clearly said that if the John Doe gets selected, if other A, B, C, D, all those employers submit the registration, then they're going to notify all these employers, and all these employers will have an opportunity to file an H1B petition for John Doe. That's all they care about. And if that is the case, I do not know how the probability or a possibility of higher number of individuals getting selected in the lottery, because if you submit 10 registration for an employee, and if all those employers are notified, then we only have 85,000 visas, including CAP, Masters CAP, and how that number will affect in reality, we do not know that. And USCIS has not provided any clarity on that with this particular H1B CAP registration. If it comes to beneficiaries has nothing to do with the registration. They have to approach the proper employers and make sure that employers are genuine ones and they get all the information and they submit the passport pages to the employer and the minimal information about their full name, correct date of birth, correct country of birth. It's very, very important. And at the same time, passport pages and the passport number. That's what the beneficiary has to provide. And as long as they get that information from the beneficiary, and if they submit, and accordingly the beneficiary will be entered into the pool, and if he gets selected, then you will be able to file a H1B petition for them. But you have to understand, only the companies which submitted the registration will be eligible to file H1B petitions, not the companies that are not submitted the registration. If John Doe gets selected, he cannot go somewhere else and get H1B filed. He has to go through only these employers who submitted the registrations in the CAP. So that is very, very important. And any questions here?
Before going to the next topic, I would like to, I have some follow-up questions on it.
Sure.
So let's say scenario A, John Doe has been applied for Microsoft. Microsoft, Google, and Facebook. Okay. And is that USCIS going to notify them, all these employers, that Mr. John Doe has been selected in this lottery process? And
yes.
Then employer has to, Facebook has to contact to the applicant and say that you've been selected and we want to file your H1, or how that going to be worked? I mean, because here we John Doe can select out of 3 only one company, right?
John Doe, as I said, once the John Doe gets selected in the lottery, all the 3 employers, Facebook, Google, Microsoft, all the 3 employers will be notified in the system saying that your registration has been selected in the lottery and you are eligible to file an H1B on behalf of John Doe. Okay, so these employers, whether it's a Google, whether it's a Microsoft, whether it's a Apple or Facebook, whichever company you call it, they have to reach out to the employee. They have to reach out to Mr. John Doe and ask Mr. John Doe that he has been selected in the lottery, and they would like to proceed with filing an H1B petition for him as they continue to intend to hire him in the pro-offered position for which they want to hire him. Okay, and that's how it works. In that way, John Doe has an option either to go with one employer or with all the 3 employers also. What if one employer wants to hire him full-time job, regular job, all next 2 other employers wants to hire him on a concurrent H1B employment, which they can do. He can negotiate for that. So
okay.
even if it's a CAP petition also, employers can file a H1B concurrent employment petitions now, right? Because because there is no relation between the John Doe, between the Microsoft or a Facebook or a Google here. They're all unique employers, and they have a unique bona fide job offers for the John Doe.
Okay.
And if John Doe intends to work for all three of them, and if you ask all three of them, I'm going to work on a regular full-time with somebody and I want to work with you on a concurrent employment, yes, he can ask for that. He can negotiate for that. He has that possibility.
Okay. So John Doe got all the, like advantages.
Bargaining power. He has more leverage. John Doe has a more leverage to demand what he wants to do and everything. If he gets selected with these three employers, and he can choose what's the best offer available for him, and accordingly choose the employer.
But let's say this John Doe went to the stamping, and then counselor can ask, like USS, that agent can ask, why did you apply 3 employees? Is that record going to be permanently stored on his like USCIS?
Its record is permanently stored on the. It is always permanently stored in the record for any immigration benefit you apply. Generally, okay, it is there the rest of your life. Okay, the thing you have to understand is that's where we're coming for the do's and do nots for employers and employees. This question is very, very relevant to that aspect. So the risk which these employees get into is when they go to the consulate sometimes, if they have multiple employers submitting the registrations on their behalf, then the consulate officers might ask, you have this many H1B registrations have been submitted on your behalf. How do you know all these employers? Do you have a bona fide job offer from these employers? And did you really discuss with them? Did you really meet with them? What did they say? How did you meet? Did they give you anything in writing, which is not required by law? Nothing has to be given in writing. But they can ask you all these questions. You may have to go through unnecessary scrutiny, even if they're bona fide job offers sometimes. Okay? What if this is fine if they're bona fide employers like Facebook, Google, and Microsoft? What if they have one bad apple along with these three, with whom John Doe went for the registration? And the bad apple is doing registration just for the purpose of making money for the registration. By taking money from the people and submitting the registrations, actually they do not have any, that particular individual or the particular company does not have any business or any intention of filing H1B petition, or even if they want to file an H1B petition, they want to do every willful fraud and misrepresentation to get the H1Bs, and they do have a record in the system of suspicious activity of illegal fraud or misrepresentation on the H1B petitions they are filing in the past. Okay, if that happens, then that's going to be a flag for the employee. Okay, at the port of entry. So they have to be at the consulate for the visa stamping, and that's where we have seen a lot of 221Gs came in the past. And the employee is not capable enough to answer properly what happened and everything, you're going to get denied under 212, A6 and A7. A6, A711 and A611, which is for willful fraud and willful misrepresentation. And if that happens, you're gone. Sometimes you get denied in 214B also, because there's something in the information they don't want to tell you or discuss anything with you. 214B usually is not only meant for the people who are intending to migrate to this country. Sometimes there could be some other factors for which they deny you under 214B, but they won't disclose any information to you because there is something triggered in the system. There's something in the system, either in their system or in some other agency system, about those individuals or the companies who are submitted the registrations for them. So that means you have to be very careful. You have to be very careful as an employee when you're trying to go do the multiple registrations. Know the history of the employers. Make sure those employers are genuine ones or not, and what kind of a attitude, how they do their business. Understand them. Understand the principles. Understand the people who are talking to you in that employer thing. You get into those things, and then you go with the registration. I would say the same thing with the employers too. The main thing make sure whom you're talking the employees, know the employee and know the attitude of the employee. Is the employee very serious coming and joining your company? Because you are submitting a registration under oath to the USCIS that you have a bona fide job offer and you want to hire him under the penalty of perjury, right? So you make sure that employee also a genuine one, is not somebody who's giving you a fake passport or fake number or something like that just to migrate to US.
No.
You know? Because you'll get
Yeah.
into trouble tomorrow if those are fake documents.
Yes.
As an employer, you know. So
Yes. Yes.
and those things are also very, very important. And you make sure that the employee is very serious enough to join your company. You know, that's why he's coming and trying to get the registration done through you. You know, those are the things which we have to clearly understand for the employer and employee. And also, employer also should understand, is this employee capable enough to communicate when needed? When the officers or anybody comes and asks any questions, is he able to communicate properly what you tell him? Is he capable enough to get trained by you?
Yes. Yes. Yes.
Where he should be able to tell the truth capably.
Okay. Okay.
You know?
So that means both sides has to do their homework properly before registration.
Absolutely.
Okay.
Absolutely, they should.
Okay. Okay. Anything that you want to add up?
Who is the head of Venkat garu, can I ask one question? Venkat garu,
Yes,
I think
yes,
you asked the question, Bhanu garu. I know a lot of people are aspirants are there. They want to file H1s, but if it is a legitimate employer, legitimate job offer, I think we should recommend that. If you are going through the staffing company, consulting company, and a small companies, we recommend filing only one petition, even with the in-house or some kind of project. Do not file multiple petitions. You will be under radar. Well, Bhanu garu, do you recommend staffing companies giving let's say that staffing company who doesn't have any proper office or small office, or two staffing companies giving the offer letters, they want to file. Do you think any risk for the employee, beneficiary in this case?
Well, I
Bhanu
mean,
garu.
it's very difficult to tell which small company is bona fide, which small company is not bona fide. That's why the employees have to do the due diligence in it. Every small company is not a bad company, you know, and every one single employee company is not a bad company. Every startup is not a bad company. As long as they have the ability to comply with the laws, and as long as they're running their company as per the required laws, and they, excuse me, if whoever is in the background, can you please mute? And sorry for that. Sorry for saying that, because it's very difficult for me to communicate what I wanted to communicate with the noise coming in. That's why.
Yes, please go ahead.
Yeah. So it's not appropriate for us saying a staffing company, body shopping, those kind of words, because
No, Bhanu garu, no, I meant to say that should the beneficiary file multiple petitions? I don't think do you recommend that? We choose, I think, my gut feeling is you should choose the one right employer who is best for you.
Well, I mean, Om Garu, one thing I would tell is this. If he has multiple offers that are legitimate and he believes that truthfully, in good faith, that those are legitimate offers and he can pursue them and he can choose them, then yes, employees can make a decision on that. But as I said, they have to be very careful in choosing the employers. Sometimes, as Om Garu said, certain factors are there which are flags for you. If they do not have any office, they're not willing to spend any money just to even rent a space to run the office, that's a flag, right? Even if it's a starting company, somebody should be able to have a financial wherewithal, at least to establish an office to run the operations of the company. Or if their employees are working at the third-party location all the time, at least they should be able to document that their employees work at the third-party client site all the time. And if they don't, and if they don't have any projects or anything like that, but they just want to file an H1B petition, then you have to understand there's a risk involved. It's a flag for any employer or any employee too. So you guys have to understand those risks. I will be able to talk about that issue more in the next agenda item, Omgaru, rather than here. You know?
Yeah, that's fine. Go ahead, Bhanu garu. Sorry, Venkat garu, go back to you. Just
Yeah,
to know. Because
Yeah,
this
thanks.
is a lot of questions are people are asking me. That's why I posed the
No, I
affidavit
understand.
certificate. I asked
Yeah.
that. Okay, go ahead,
I
Venkat
mean,
garu.
I would say you
Yes.
have a choice. Employee has a choice. He can choose what's best for him. You know, and there is no harm in doing multiple registration, going with multiple employers to seeking the multiple registrations. At the same
Yeah.
time, there is no harm if you don't do that also. But what if you go with only one employer and you get selected in the lottery? What if that employer turns out to be a bad guy? You know, so
Yeah.
you
Yeah,
have to assess the risk everywhere also. You know?
Yes, yes. When the next topic would be like MSA agreement, SOW project,
projects and products
all
and
these documents, it's a part of the process. Am I right? I mean, like,
it's sir, I
I
want to tell you
Yeah.
all very important this
Okay.
one. You all have to understand this. Okay.
Sure.
After 2020, when ITSR Alliance filed a lawsuit in 2018 about the rescission of Neufeld memo and the itinerary memo, saying that they're unlawful, the memos are not controlling body of law, and they have been executed and implemented in violations of Administrative Procedure Act. When the court agreed with the ITSR Alliance and basically rescinded the Neufeld memo and the itinerary memo, then the USCIS came out with the ITSR Alliance memo explaining that employers are not generally required to provide any MSAs or SOW projects or product information for the H1B purposes. As long as they can establish that they are bona fide employers and they have a bona fide requirement for the beneficiary, job for based upon the nature of the job and everything, and also responsibility of the job in which they intend to hire, and prove that the job is a specialty occupation, H1Bs should be approved by the USCIS. Okay, and so it's not necessarily required for you to provide an MSA, SOW projects and products as of today. Very important, as of today, because as per the current regulatory situation, as per the current laws and the current regulations. However, with the H1B modernization rule, H1B integrity and modernization rule of 2023, or whatever we call it, basically we call it as H1B modernization rules and regulations, right? That's what we generally call it. On that, they bought the proposals on changing the definition of specialty occupation itself, and also the requirements for the establishing valid employer-employee relationship for the H1B purposes in the regulations. And also, they also have other issues in them. Is one is H1B lottery system, and the other one is the fee hike for everyone, about all the petitions, all the files, all the things, and changes to the STEM program and also L1 program and I-140 programs. Okay, so all these things have been included in the H1B modernization rule and integrity rule regulations, and they're trying to come into that. So as per the proposed regulations by the USCIS, then they're going back prior to ITSR Alliance memo requirements, even a little bit stronger than that also, because they're requiring now, they may require you now to show you have a valid employer-employee relationship through right to control, who's controlling the job, and they're establishing that they're demanding you to provide, if you're a consulting company and if your employees work at the third-party client side, then you have to provide agreements, purchase orders, or any other document showing the relation between all the layers involved in between. For example, if your business model is either EC model or EVC model or EVVC model or EVVC model, whichever model you are, or your SEVC, like a SEVC also, subcontractor, employer, vendor, and contract client model also, still, then you are required to provide MSAs, SOWs, and products, which is layered in between all the companies, all the entities involved in between, or all the parties involved in between. So these are the proposed changes which they're making, and also they made changes to the definition of specialty occupation also. So they're going more towards clear and convincing, more towards the highly specialized knowledge in nature based upon the experience gaining rather than the minimal educational requirements, what is the current definition of specialty occupation is. And also they're interpreting the requirements of a specialty occupation, statutory definition of specialty occupation very narrowly. When they say bachelor's degree at a minimum in a field of endeavor that is related to the field of endeavor in which beneficiary is required to work, that field of endeavor, related field of endeavor, the term related is being defined very narrowly in coming regulations. So those are the complications we're going to see if the new regulations come into picture with this fiscal year 2025. However, we have to understand this. There is a time for these new regulations to come into picture. Okay? The time is that it's expected that sometime they're going to pass the new regulations sometime in May or June, and after passing those regulations, they have to wait 60 days to implement them. That means by passing the regulations in May or June, they're not coming into effect. They will start coming into effect in July or August, depending upon when they pass. But however, if your cases are pending at that time, you will be subjected to the new regulations at that time. Therefore, we are advising our clients, whoever is our clients, if you submit the registrations and they get selected in the lottery, and if you think some employees are very, very important for you, you cannot afford to lose them, immediately file their H1Bs in premium processing without waiting till June filing their cases, without waiting till the last week of June filing their cases. Because we anticipate these new regulations will come into effect. As of today, you do not require these documents. Therefore, you can file H1B petition establishing valid employer-employee relationship without providing these documents and get H1Bs approved, like how it is happening in the past 3 years. You know, and we are advising everybody also, it's okay to spend extra money, $2,805 for premium processing, because from February 26th, it's going to be $2,805 for H1Bs and I-140s. It's okay to spend that extra money, file it in premium processing. We are the attorneys. If any RFE comes, we will make sure that we respond to those RFE on expedited basis and try to get the approvals by first week of May or second week of May, so that you will not be subject to the new regulations. You know, at least for this CAP, you have that option availability. But if you delay in filing those H1B petition till June or May and everything, and if you file it in regular processing, probably again you may, if these regulations pass, then you may be subject to the new regulations. Then you have to go through all that requirement, and you'll have a lot of issues with the USCIS, with the site visit officers and everything, because these regulations are also making site visits participation mandatory. Before they were not. They were only voluntary. If you want to participate, you can participate. If you don't want, you don't have to participate. But now they're making it mandatory. Okay, that means failure to participate in the site visit compliance review can be used against you for non-compliance of the H1B for petition filing. Right now, they cannot. They can only say that the review is incomplete. We could not get enough evidence to make any evidence or anything like that. Or they have to adjudicate, they have to provide the review based upon the information they have, but they cannot say that you are in non-compliant right now. But at the time, they're going to held you non-compliant if you don't participate in the site visits. And every case you file, you expect to go through the site visits in coming days. And every visa petition you seek abroad, expect a visa compliance review by the Department of State through FDNS. Okay, so be prepared for all those things in coming lottery and everything. So it's important to hire. I'm not saying that you're all not capable. If you're filing by yourselves, you can continue the same practice, but understand that it's important. Everybody has to understand what's their skill set is, what's their time is, where they can put that effort and everything. If you can put your effort in marketing individual, getting placement, the time you want to spend on getting this H1B preparing improperly or properly, whatever knowledge you have based upon your knowledge, I believe sometimes it's going to be inconvenience for you guys, because we bring that expertise value as an attorneys for this type of situations, you know. So you think about it, where to spend money, where not to spend money, and accordingly make a decisions what's best for your organization, and accordingly approach the issues. That's what our sincere 2 cents are during this session.
Follow-up question, Andy. This is follow-up question. About hiring OPT student as an intern and sponsor them as an propose them as an H1 registered as an lottery. So is there any do's or don't do's on that process?
There is nothing like that. Actually, the biggest possibility, if the new regulations passes, for you, the easiest way of processing H1B is hiring the students in this country, hiring the individuals who are in this country, rather than trying to hire somebody who are in India. Because you'll have a lot of scrutiny at the consulates while applying for a visa and everything. See, the problem with that is you are going through the scrutiny 3 times a year. One with the Department of Labor, one with the Department of Homeland Security, and again with the Department of State, if you're filing for the individuals who are in India all the time. So hiring OPT students is always an advantage because they're already available talent over here, and they're like a sponge. Most of the OPT students are like sponge for you. They take in a lot of information because they're already exposed to the US environment, working system and everything, right? So it will be easy for you to manage. I mean, to do things and everything. I'm not saying that is only the way you should go, but there is no inherent problems by hiring OPT students. It's actually advantageous to the businesses if you can find qualified and quality students who can really help you growing your business and also themselves also growing in part of that relationship.
Okay, good. And one more question. The last time more than the limit, they accepted the applications, right? You know that, right?
Always they accept more petitions.
So this year also, that is the possibility there?
Absolutely, Andy. Absolutely, that's always a possibility because that's the way it works. Because very likely that most of the some of those petitions will be denied for several reasons, for error or not qualifying, not eligible, or does not meet the requirements of specialty occupation, or does not meet the valid bona fide employer-employee relationship, or individual does not qualify for the position which they are seeking. There could be several reasons why several petitions will be always denied. And based upon the, they have a very complicated algorithm which they use generally, which is very, very difficult for me how they calculate the algorithm, because that's why it's called algorithm. It's the computer run algorithm. It's not me generally running it, right? And so based upon that, they decide how many petitions needs to be accepted, how many petitions need not be accepted. It's all about the data, nothing more.
Okay. And that's all from my side. And can anybody take the questions, or do you want me to continue? Team, immigration team.
Yes,
okay. Venkata Rajagaru Kotari.
Yeah.
Please take the floor, please.
Sure. Bhanu garu, thank you so much.
Always, sir. Always.
Okay, there are a couple of questions our team have. So probably I will proceed with the chart right now.
Sure.
Yeah.
Yeah, Venkata, do you want me to go the first question?
Yeah, proceed, Srini. Proceed.
Yeah, Bhanu garu, this is Srini, sir. One of the.
How are you?
Yeah, I'm good, sir. Thank you. Thanks.
Yeah, Bhanu garu, just I want to say these are the volunteers who make this Atmiya a great platform for our community. You know that.
Yes.
I want to appreciate Srini and Venkata and all this. Atmiya has 9 chapters, so we have across the United States, just like Yeah, thank you.
Thank you, Bhanu. Yeah. Bhanu garu, the question from one of the participants, sir. Assume that primary applicant got I-140 approved and spouse is on EAD. If the primary applicant lost the job, still we have a 6 months grace period too. Earlier it is 60 days, right?
It's only 60 days.
It's now also 60 days.
It's only 60 days or till the date I-94 expires, whichever is shorter.
Okay. I think a second question. From H4 to H1 and H1 to H4, do you have any restriction to switch? How many number of times?
There are no restrictions at all. It's about individual's choice.
Thank you. Yeah, those are the two questions from chat. And do you have any questions? Please raise your hands and we can go by in order.
Hello, this is Venkat Parchurandi.
Oh, Venkat Garu.
Good morning, good evening, everyone.
Good evening, sir.
ఈ H1 కి expenses ఎంత అవుతాయండి?
Sir,
And,
that's a very good question, sir. I did not talk about the fee hike. Very glad that you brought this question, Andy. Really appreciate this. Sir, unfortunately, the USCIS has significantly increased the fees for all types of petitions and applications and the benefits we are seeking with the USCIS. And their reasoning is Congress has allowed them to increase the fees based upon the consumer price index. That means based upon the inflation. As this year's 23 has seen 8.5% increase in the inflation, and accordingly they are going to adjust the pricing of the fees. Therefore, these fees will be there until 2027. And again in 2027, they're going to adjust the pricing based upon the inflation consumer price index at that time. Okay, so as that's the reasoning, that's the rationale they've given for the fee hike, because some of them are very abnormal and very unusual. For example, for H1Bs, we all have to understand this. USCIS is making the employers to take the blunt or to take the burden of paying the fees for the refugees and asylees coming into this country for processing their applications and their cases. If you're filing an H1B petition or an I-140 petition, I don't know how ridiculous it is, but the Dugran, who is the advisor to the USCIS director, he was one of our calls while I was with the meeting with the AILA, American Immigration Law Association. He said that Congress said that they have to get these expenses from somewhere, and there is no possibility yet. So somebody has to pay for these expenses. Therefore, they're asking the employers to pay for these expenses. These are ridiculous reasoning and rationale provided by them. But unfortunately, irrespective whatever reason provided, all the employers have to suffer now because of that. And the fee hike has been significant. On average, if you're less than 25 employees company, your fee is increasing for the CAP H1B petitions around $930. Actually, a little bit less than that. Actually, it's increasing around $620 for the employers less than 25. And if you're 25 or above, if you're more than 25, then your fee is increasing to $920. Increasing by $920. What we mean by that is, right now the USCIS fee is regular processing fee is for the H1B CAP petition is $1,710. This $1,710 actually has 3 types of fees which we'll be paying to the USCIS. What are those 3 types of fees is H1B base fee and the ACWIA training fee and anti-fraud fee. The amounts for anti-fraud fee is $500 if you're filing the first petition. And the ACWA fee is if you're less than 25 employees, 25 or less than 25, ACWA fee is $750 and the H1B base fee is $460 right now. And they total to $1,710 as of today. Now, USCIS, what they did is they increased the base fee of H1B base fee from $460 to $780. That means by 70%, they increase the H1B base fee to $780. And then they require you to pay an asylum program fee in the amount of either $300 or $600, depending upon the size of your company. $300 if you have less than 25 employees. That means you're paying $320 plus $300 in addition to the $1,710. That means $1,710 plus $620. That means your fee is going to be $2,330 if you are an employer less than 25 employees. If you are more than 25 employees, then you're paying $1,500 in ACWA fee, $500 anti-fraud fee, and H1B base fee of $780 plus asylum program fee of $600. So from $2,460, which you used to pay before, normally, now it's going to be $2,460 plus $920. That means it's going to be $3,380 for the H1B filing fee if you have 25 or above. And in addition to this, if you have 50 or above, and if you have, it's $3,380 is the H1B filing fee for you if you are 25 or above. In addition to that, if you have 50 or above employees in a company, and the 50% of the above, and the 50% of the workforce of that company is on H1B visa program or L1 program, then you have to pay additional public law fee of $4,000. Okay, so $3,380 plus $4,000, that means you're paying $7,380 for H1B filing fee if your employer has more than 50 employees and the 50% of the workforce is an H1B or L1B visa or L1 visa or L1 program. Okay, it doesn't matter whether it's an L1A or L1B. Okay, and this is what it is. But and also you have to remember along with this, from the April 1, 2024, you don't have to pay anti-fraud fee for the amendments or extensions, for those petitions. You're only required to pay anti-fraud fee for the transfer petition, change of status petition, new petition, or a concurrent H1B petition which you're filing, initial concurrent H1B petition. Okay, for these things you have to pay anti-fraud fee. And the same thing continues right now also. But ACWA fee, you only pay for the initial filing and the first extension you're filing. You don't pay ACWA fee for the amendments or for the second extensions or any extension thereafter. But however, irrespective whether it's an extension, second extension, third extension, whether it's an amendment, whether it's a change of status, whether it's a transfer, or whether it's a concurrent H1B, you still have to pay asylum program fee. Asylum program fee is, if you have less than 25 employees, $300. If you have more than 25 employees, you're paying $600 for every H1B petition you're filing, period. That is no excuse for that. And also, every employer who's filing an I-140 petition will be paying asylum program fee in the amount of $600. There is no concession over there for the employers. If you're filing an I-140, you have to pay $600 along with the I-140 filing fee. Okay.
Thank you.
So, and also premium processing fee also increased to $2,805 from $2,500.
Okay, that's great. That means less than 25 employees అయితే మనకి ప్రీమియం ప్రాసెసింగ్ ఎంత అవుతుందండి?
Less than 25 employees, but premium processing is $2,805 for the CAP cases. From February 26th onwards, any case that is receipted by the USCIS February 26th or after, you have to pay $2,805 for the premium processing if it's an H1B or I-140.
That is it including all the fees, lawyer and
No,
INS?
sir. These are only USCIS fees.
Yes.
What about lawyer? What about attorney charges?
It all depends upon each and every attorney and depends upon the employers.
Yeah,
Okay.
Venkata garu, attorney fees ranging from $650 to $3,000 based on attorney. That's what Bhanu garu is saying.
Okay.
Bhanu garu, correct me if I'm wrong.
Okay. Ratnakar, I think he raised the hand. I think
1 minute, sir, Venkatarya. I think Bhanu answered. Yeah, we can go in order, Venkatarya.
Okay.
Yeah, Ratnagar question answered. Ratnagar garu, so Bhanu garu, you covered this fee topic, right? But attorneys, sir, is varies as said. You can reach out to the attorneys, individual attorneys, basically.
Yeah.
And Satnar
Next.
garu, please.
Yeah, just sorry అండి, one more time. H4ED కనుక పని చేస్తుంటే అది 60 days నుంచి 180 days కి పెరుగుతుంది అనేది పని చేస్తున్నప్పుడు, చేయకపోతే కాదు, పని చేస్తుంటే is it still 2 months 60 days or it is
The
it doesn't matter?
grace period is only 60 days or till the date I-94 is valid, whichever is shorter.
Okay, so it doesn't makes any problem if, even if EAD was doesn't makes any sense.
Doesn't make any sense. I mean, if he has an EAD, you can work on EAD, that's a different thing. But if it comes to H1B, the grace period is available only 60 days or till the date I-94 expires, whichever is shorter.
Okay, yeah, thank you, sir.
Yeah. Thank you, Bhanu garu. Next, Bhavana
థ్యాంక్ యూ
garu.
అండి. థ్యాంక్ యూ భాను గారు.
Sure, sir.
Bhavana garu, please go ahead, Andy, if you are there.
Hello, Andy.
Hello, Andy.
Hello, Bhanu garu. Thank you for all your information. So I am a master's student. I graduated with a master's degree in September, and I've been working with an NGO which works with Black young adults. They do a lot of community work for Black young adults, and the CEO is willing to sponsor my H1B application. But the key here is this is the first time he's working with somebody who is an F1 student. And there is an attorney with the NGO, but she's not an immigration attorney. So if I would like some help in
We are
trying to take
very
this
happy to help
H1B
you, Bhavana
process
garu.
forward,
Kindly reach out to us.
what do you suggest I do the best?
We are very happy to help, and reach out to us, and we are very happy to help and connect to your employer with us, and we'll guide them how to file an H1B petition for you. And if they're willing to work with us, we're very happy to help.
And one more thing అండి, చాట్ లో భాను గారి వెబ్సైట్ లింక్ కూడా పెట్టాను. సో మీరు if you have there it is the phone number and everything. Yeah, please make use of that. Direct connected to the Bhanu garu with the phone number.
Actually, I'll provide my contact details also, Andy. It will be easy in that way. It's my mobile number, my office number, everything I'll provide there.
Okay.
So Bhanu, my follow-up question is
Yes, go ahead.
What are some things that I have to keep in mind if I'm trying to do this?
I mean, it all depends upon your position, Kadandi. It all depends upon your position, who's the employer, what is they offering you. We have to look into all those aspects, and it's very difficult for me to comment here or discuss here because this is something which you have to talk to me privately about your job, your employer, and everything. Based upon that, we will tell you what is the information is needed, what steps you need to take, and everything. These things does not happen like this. You have, because I need to know complete details about your employer and their intention to hire you, what position they want to hire you, what is the salary they want to offer you. Because sometimes the position which they want to offer you, the salary what they want to offer you may not match, may not meet the requirements. So we have to look into all those facts.
Okay. One last question. Thank you so much. So because this being an NPO, the salary that was projected to me was very minimum. It's like the bare minimum. So do H1B filings happen with the candidate having no salary from the NPO?
No, they have to pay the salary, everybody. Whoever is either on H1B petition, there are minimum requirements which they have to meet, employers. Okay?
Okay, sure. I will reach out to you. Thank you so much.
Sure.
Yeah, thank you, Bhanu garu. Next, Ashok garu. Ashok, you are there? Please unmute yourself, sir. Ashok Antukala. Okay, I think looks is unmute. Durga garu.
Yeah, I'm here, sir.
Yeah, Ashok garu, please go ahead. Durga garu
సో
next.
ఇందాక అది 60 days దన్ను లేదంటే I-94 విచ్ ఎవర్ ఇస్ షార్టర్ అన్నారు కదండి. సో అలా అది H1 ఇండియా వెళ్ళిపోయి H4 EAD మీద వాళ్ళు కంటిన్యూ చేయొచ్చా?
చేయకూడదండి. Because H4 status is dependent upon H1B maintaining legal status in the US. If H1B violates status, H4 automatically is violated.
Okay. ఓకే, థ్యాంక్ యూ. అండ్ రీసెంట్ గా మన H4 వాళ్ళకి మనం వర్క్ ఆథరైజేషన్ మరి అప్లై చేయక్కర్లేదు, వాళ్ళు బై డిఫాల్ట్ దే ఆర్ ఎలిజిబుల్ టు వర్క్ విత్ దేర్ H4 ఎక్స్టెన్షన్ అన్నారు కదా, దట్ ఈస్
That is incorrect,
is that
Andy. That rule has not been come yet. That is incorrect. That possibility is only available for L1, L2s and E3s. E3 dependents. Okay. And that's called E3S, E3 spouses, or L2S, L2 spouses, not for H4s.
okay,
H4s
okay,
still have to apply for EAD.
okay, okay, thank you, sir.
Thank you. Durga garu, please unmute yourself. Durga garu, your voice is not audible. Yeah, we'll go with next question. Vamshi garu.
Hello, Andy. Good evening, everyone. First of all, thank you so much for providing us this opportunity, Andy. So my question is, what are the best practices for a first-time H1 filing employers? And what are the prerequisites, or what are the best practices, Andy?
It's a very broad question, Andy, and it's a very good question, but at the same time, it's a very broad question. And the practices is very important them to comply with the laws and the regulations. They have to understand the minimum requirements of an H1B petition they're filing. If their intention is to file an H1B petition for any employer, what are the minimum requirements? LCA compliance issues, right? And when you're taking an LCA, what are the factors you are considering into LCA? And how you're determining a salary? All those factors are very, very important. Of course, we lawyers are there to help you, guide you, and everything in that. But you have to listen to the lawyers, what they tell you, and you have to implement that in your company, and you have to document everything in the company, all those things. So as long as you're complying with all those things, you should not have any problem. First of all, make sure that you have a valid employer-employee relationship. That means you have a bona fide, you have a legitimate job offer and job requirement for the individuals. These are the basic things which you have to understand. And you have to have the financial wherewithal also to pay the wages offered. If you do not have any cash or revenue, still you can meet the requirement if you have a project. Like, for example, if the individual is going to work at the X project for the Y company, and you have a purchase order and the MSA for that, we can establish your financial wherewithal based upon that, even if you're a startup company. So these are the minimum things. Minimum things is first is onboarding procedures for employees. You have to have a proper orientation session for employees whenever you're onboarding the employee about company policies, company practices, and the requirements and the etiquette which employee has to follow in the company. Best way is establishing an employee handbook and giving it to every employee. Making sure that employee handbook is prepared competently by lawyers, not cutting and pasting from the ChatGPT or from a Google or anything like that. So these are the things which you all have to understand. When we tell them that, you may think that we are pitching to for our services, for our fees and everything. That's why I don't like to say those things. But the reality is, when you try to do your own cooking, you'll have a problem with it. There's a difference between your cooking and the international recognized chef cooking food. Always it tastes different. The same thing also. Okay. You all have to understand these things, very, very important. So these are minimum things. You have to understand where to spend money, where not to spend money also. Okay? Spending money for a $300 Macallan bottle is not important. Spending money, those $300, to get a lawyer's advice and setting up the process with the lawyer is very, very important. So it's all about our prioritization, what is important. If you're very serious about your business, these are the things which you have to follow. See, as I said, it's not mandatory that you need to have a physical workspace, but never, ever use virtual addresses to file an H1B petitions or LCS.
Got it. Yep.
Okay. You can, if you have a work from home, it's a home-based business, you can still file H1B petitions, but you have to clearly disclose to the USCIS saying that it's a home-based business. Obviously, in a home-based business, only problem comes is if you try to show in-house positions, you cannot show that, because you will not have your HOV permissions and HOV authorizations to do commercial activity at your home.
Understood. Okay.
You have to show that the business where you're conducting that you are licensed to do commercial activity, conduct a commercial activity. It's very, very important. USCIS always looks into these factors to flag somebody, whether somebody is committing a misrepresentation or somebody is a, this company and that company, everything. We do every year at least 100 cases for home-based businesses, but we disclose them to the USCIS saying that it's a home-based business and the employees work at always third-party client side. And the LCA also reflects that information. And one more thing you have to understand this. So if the employee changes the location and if the job requirement changes, that is material, you have to file an amendment prior to that individual actually starting the work. And you should not fail filing an amendment. So these are all, and you have to maintain public access files. You have to do proper LCA postings or a notice of job, notice of LCA postings at least before the on or before the employee joining in that location for 10 businesses or work location. You have to comply all these things. You have to record all these things. Have a separate HR file. Create an HR file. Do not commingle HR along with your public access files or H1B files. Understand them. Get proper training from the employers and provide a proper training to the employees. And every weekly conduct the scrums or stand-ups with your employees. Just have interaction with them. Those things are very, very important. And pay timely to your employees. That is very, very important. And understand the Department of Labor regulations also, meeting the salary requirements. Those things are these are all the things which you have to understand prior to getting into any business, especially with H1B regulations.
So the owner can for EAD or a GCEAD, right? That's not a problem.
Even for them also, very important to have a proper thing. And also every employee, irrespective of their immigration status, if they're authorized to work in this country, you have to treat them equally, right? So you have to have a proper documentation, proper intake process, proper I-9 verifications, proper documentation of HR, all these things, everything you have to maintain. Otherwise, you may end up facing discriminatory lawsuits against you from them, right? So keep that in mind, and those things are very, very important.
Sorry, sir. My question is the owner can be a H4 EAD, right? H4 EADs can file H1, correct? Or a GCEAD?
Yes, they can file H1Bs. There is no restriction on that.
Okay.
As long as they do it genuinely, otherwise they'll be looked at with a different IND. That's all I can say.
Okay. Thank you.
Yeah, thank you, Vamsi garu. By interest of time, sir. Okay. Now Magnetar Consulting.
Yeah, namaste Andy. Na peru Midin. So we are a startup. We started last year actually. And is there a specific requirement for office workspace, like in the square feet undali?
It all depends upon how many people you're planning to hire, Andy.
Okay. So, but for the USCIS, is there a office workspace requirement?
They require for any businesses. How do you do a business without having a proper office space?
No. So the question I have is, we have an office workspace of 550 square feet. That's very small, right? To make it like a decent workspace.
It all depends upon Mithun Karu. It all depends upon how many. It all depends upon how many employees you intend to hire for that location.
Okay.
You cannot hire 20 people in 550 square feet, right? We are going to.
Yes. Okay.
It's a common question.
Okay. Is there any change in pay wages, like salary wages? So for filing LCS?
Sir, every year the new wage pay cycle, new wage pay scales will be released by the Department of Labor every year. The fiscal year for that is from July 1 to June 30th. So every year, July 1st, the wages changes. Okay. So as of today, the wages that have been released on July 1, 2023 is governing.
Okay, got it. Thank you. Thank you so much, Bhanu.
Thank you, Midin garu. Next to Sai Tota garu. Please go ahead, Andy. So please be crisp, Andy, to give the time. Okay, already we are hour and a half.
Yeah,
Tiger.
we are almost 10:30. We crossed 10:30. So please make it quick. And thank you, Bhanu garu, taking extra time for to answer them questions.
Yeah, Sai garu, go ahead and please. Sai Tota garu.
హలో అండి, నమస్తే. భాను గారు నమస్తే అండి.
నమస్తే సాయి గారు.
థ్యాంక్ యూ అండి. ఫస్ట్ ఆఫ్ ఆల్ మన ఆత్మీయ గ్రూప్ ఇంత పెద్ద ప్లాట్ఫామ్ క్రియేట్ చేసి అందరికి మా గైడెన్స్ కానీ హెల్పింగ్ కానీ చేయడం నిజంగా చాలా చాలా అప్రిషియేటివ్ అండి. మాకు రీసెంట్ గా H1B అప్రూవ్డ్ అయింది. మేము వచ్చేసి న్యూజిలాండ్ లో ఉంటున్నామండి లాస్ట్ 15 years నుంచి. అండ్ వీఆర్ ద సిటిజన్స్ ఆఫ్ న్యూజిలాండ్ హియర్. We got a family of my wife and 2 kids as well. సో మేము యుఎస్ కి వద్దామని చెప్పే ఆలోచనలో ఉన్నాం రైట్ నౌ. సో అనుకుంటుంది ఏంటంటే అండి, ఒక్కసారి అక్కడికి వచ్చిన తర్వాత మా పాసిబిలిటీస్ ఎలా ఉంటాయండి? బీయింగ్ న్యూజిలాండ్ సిటిజన్స్, వాట్ ఆర్ అవర్ పాసిబిలిటీస్ దేర్ టు బి ఏబుల్ టు సెటిల్ డౌన్? The same time, the main reason for us to be moving overseas, which is USA, is for the kids' education and everything, as well as for us to be settled as well.
So the possibilities is this. I mean, although you're a New Zealand citizen, if you're looking into the becoming a permanent resident in this country, still they will look at you based upon your country of birth or your spouse's country of birth. Okay, and so if it comes to green card, unfortunately, you'll be falling in the same line if you're a citizen, if you're born in India, or if your spouse is born in India, like every other Indian national in this country. And if you're looking for regular route, which is basically an EB2 and EB3 category, you're talking about several years to get a green card. Okay?
Oh, wow.
But however, being a New Zealand citizen, if you want to do business in this country, if you want to invest in this country, you have an option of doing treaty visa, which is an E2 visa or an E1 visa, depending upon treaty trader visa, or investor visa, which is an E2 visa. Okay? So you have those possibilities for you. And those allows you to stay rest of your life in this country, as long as you're doing the business, as long as you're being entrepreneurial in your business.
And it was just so funny that he was also taking back. He was so sure that like.
Could you please mute Andy? Thank you. Yeah, go ahead, Bhanu garu. Sorry.
Yeah, I mean, that's all. I mean, you have that possibility. And also you have a possibility to look into whether you have enough money to invest in EB5 program, right? And that is also a very good possibility. And the other possibilities is whether you qualify for extraordinary ability visa, EB1A or EB1B, or if you're coming on, if you qualify as an executive or a manager for MNCs, basically for overseas companies and US companies, which is basically the same company as intercompany transferee, executive or a manager is intercompany transferee, you may qualify for EB1C also. And also is if you qualify for NAW I-140, National Interest Waiver I-140, you can try that route also. But still, that is an EB2 category, which will take several years for you.
Oh, right. Okay.
Yeah, thank you, Bhanu garu. Next, Opel Soft LLC.
Yeah. This is Chaitanya Sethi again. Namaste, Bhanu garu. What's your take on Noir applications? Like somebody who has a Noir, and do you think we can straight away go with them, or better to restrict?
See, if somebody has a Noir, first you need to find out exactly what the Noir is about. You know, when USCIS issues a notice of intent to revoke, that means USCIS reviewed the petition again, and they felt like there is something deficiency in the petition, and they erroneously approved initially when they approved that petition. That's why they're issuing the Noir. So when the Noir is issued, first you have to look into the subject of the Noir, content of the Noir, and whether the Noir is addressable or not. If the Noir is addressable, then you should respond to the Noir. Make sure that you respond to the Noir and get the reaffirmation from the USCIS that the initial what you submitted was perfectly approvable, and there is no changes, no requirements that need to be made in the petition. And whether to hire somebody with a Noir or not, as I said, it's all about the possibilities. If somebody gets a Noir for multiple registrations, it's better to avoid hiring them, because If they revoke the petition, they will be subject to the cap, and most likely the new petitions will not be approved. Most of the times. Okay, unless they go through the lottery again. So it all depends upon it. It's a very case by case specific. It's very difficult for me to generalize and give you an answer on that.
Yeah, but if they go through the lottery again, it's like a reset or
it's a reset.
Okay, perfect. Okay, and what's your take on consular applications?
Well, I mean,
If
as
there
I said,
is no project.
as I said, consular processing petitions are demanding client letters, projects in MSAs, if the employee is a consulting company. Okay, and although current regulations does not require that, consulate saying that these regulations is not applicable for us. Our adjudication policy is different from the USCIS adjudication policy. Okay, so when you're sending to somebody to the consulate for processing, check what petition you file, for what position you file, and how you file, and accordingly you need to make a chance and decision whether to send for the stamping or not.
Okay.
Okay, thank you, Chaitanya. Thank you, Bhanu. Next, Raghubabu Rajnala.
Yeah, good evening all. Na peru Raghubabu Rajnala. I'm calling from Houston, Texas. So my question for my H1B immigration question. So Bhanu, my question is, so currently I'm on H1B extension approved. So my project is going to be ending the next week. So for going for the stamping, is it possible for the stamping without any employment letter and end client letters? Can I go?
Very likely you end up in 221 GN.
Oh, that means it's a highly risk, right?
Highly risk.
Okay,
I mean,
so yeah.
And also depends upon how your employer filed your petition also.
Yeah, my employer petitioned on my existing client, but that will be finishing in the next week.
Yeah, if that is the case, then it's not advisable for you to go for the stamping. Unless you find a new project and file an amendment and the amendment is approved, I would not advise you to go for the stamping.
Oh, okay. Once I got the opportunity, then only based on that employment, I have to go in for the stamping, right?
If you want to go for the stamping, yes.
Okay, yeah, fine. Thank you, sir. Thank you very much.
But did you check if you are eligible for domestic stamping?
Domestic means I need to go for Mexico or something like that, or
No. Yeah, inside US only. There is a USCIS. In America stamping, okay. There are some guidelines, I think. Okay, we can check.
Okay, sure. I'll
You
check.
can ping an immigration group and we'll provide more details. Yeah. Thank
Sure.
you.
Thank you, sir. Yeah. Bye.
Shekhar Pilla garu.
Yeah, Bhanu garu, thanks for time, Andy. I have a question about 140. See, for example, employer A filed the 140. After filing 140, after 6 months, if you move to employer B start filing the 140, he put the date which is filed on employer A. Then what will happen, sir, that employer A 140, it will be expire, or we can go back to employer A and file 485?
Employer A petition will remain valid as long as employer A continues to process your green card.
Okay.
For the adjustment of status purposes I'm talking about.
Okay.
So if the employer A withdraws that I-140, then you cannot go ahead and file adjustment of status with employer A unless employer A again refiles I-140 along with the 485.
Okay.
So once the I-140 is approved, the labor will, if the the requirement is, so I think I will be going into too deep. It may confuse you and every audience about there. I don't think it's worth for me. So this is for your question. This is the answer. The answer is that you will be able to go and file adjustment of status with employer A, provided employer A is ongoingly, continuously supporting your I-140 petition. He has not withdrawn that one, and they intend to hire you once you get a green card.
I mean, after porting the date to employer B as well.
It doesn't matter, sir. Priority date is always grandfathered by every future I-140 you file. The priority date is retained for you because the initial I-140 is approved for you.
So what my understanding, if he's not withdrawn my 140, then I can go back to employer A, I can file 485.
Yes.
Until he's not withdrawn, I'm good to file 485 with employer.
Yeah, even if he withdraws by himself voluntarily, he can again refile that I-140 and you can go and join them and file 485.
Oh, I mean, he can only withdraw for 140, but he can't do anything perm, I guess, correct?
Perm remains valid forever.
Oh, then if he withdraw 140, I can go back to employer A. I can ask him to file 140 and 485 same time.
Yes.
If date is current.
Yes.
Okay. Thank you, sir. Thank you very much.
Thank you, Andy. Next, Shiva Gajula garu.
Hi Andy, can you hear me?
I can hear you, sir.
Bhanu garu, chala thanks Andy. Okay, so basically my question ఏంటంటే my previous H1B has been revoked by USCIS due to I'm working remotely instead of end client.
Okay.
So is that impact my current status? Now I moved to the new company and my H1B approved another 3 years. So
That's okay. That's okay, sir. You're in valid status because with your current employer, you're valid H1B. That is with
yes.
the employer. So,
but the point is, it seems like when I received the intent notice of revoke, it's stating that the LCA has been like a misrepresentation. Your work location.
That is your employer, not you.
Okay.
Okay. The employer failed to file properly an amendment, timely amendment, because you're working from home rather than working at the client location.
Yeah, okay. Basically the end client is in Michigan, but I work from remote.
Yeah. That's what I'm saying, sir. Because the work location has been stated in the LCA, must have been the Michigan work site location, but you are working remotely somewhere in the country.
Yes.
And because your employer failed to file an amendment and state correct work location remotely where you were working from, that's why there was a material error committed by the employer, not in compliance with the H1B regulations. Therefore, they're in violation of H1B regulations, and that is what the reason why they revoked the H1B petition, and that led you out of status because of that.
Okay.
But however, I'm assuming you got an H1B approval. That means you got an I-94 with the new company.
Yes.
Because of that, you are okay with it. And this H1B petition will not impact your CAP number. Therefore, you are okay with it. You are okay?
No. Okay. So,
you're okay with it, and you'll be able to file for transfers and extensions, everything in the future. Nothing to worry.
Okay. And one more question, extension. So when I spoke with my current employer, so he's saying that if the LCA has been filed like a fraud or misrepresentation, then maybe I am coming out of CAP quota, then it might go back to...
Sir, your employer is not a lawyer. Sorry to say this. And they do not understand the proper regulations. That's the whole problem here. Okay. That if it's a multiple registration case, and if they decide it's a fraud and misrepresentation, and they can revoke and basically subject that lottery to the coming fiscal year. Okay. But here, the fraud or misrepresentation about the misstating the work location by your employer, it doesn't mean that your H1B petition has been revoked and your CAP number has been reinstated to the new fiscal year. Okay. It is a failure to comply. Of course, they may find a fraud or misrepresentation based upon the information provided by your employer, but that's what happened here. And based upon your facts, I've seen several times in the past, like yours, where I never had a problem filing an extensions or a transfer under your situation. But if something happens in your case, I do not know exactly, because I have to see your lawyer and I have to see your denial also, your revocation petition notice also.
Yeah, still I haven't received because I got the notification day before yesterday.
I have to see your revocation notice. I have to see your revocation notice and also your lawyer, and maybe I can look into that. But point here is this: most of the times they are boilerplates, so not to worry. But in your situation, you will not lose your CAP number. Therefore, you're still exempt from the CAP.
Okay. Thank you, Bhanu garu. Can I connect offline? I have your number.
Definitely.
So maybe I can. Okay. Thank you, Bhanu garu. Yep. Thank you. Thank you.
Thank you, Shiva garu. Please connect offline with the Bhanu garu to assist.
Yeah, sure. Thank you.
Thank you, sir. Yeah.
Durga garu, go ahead. And might be today's last question for you. Is already 15 minutes delay. Yeah. Durga garu, you are there, Andy? Durga garu, we are unable to hear you, Andy. Looks like.
దుర్గా గారి క్వశ్చన్ నాకు తెలుసండి, ఆయన పింగ్ చేశారు.
చెప్పండి సార్.
ఆయన అడిగిన క్వశ్చన్ ఏంటంటే ఎడ్యుకేషన్ ఎవాల్యుయేషన్ ఒకసారి చేసినాక ఎన్ని ఇయర్స్ వరకు వ్యాలిడ్ ఉంటుంది?
It's valid indefinitely.
Indefinitely. Okay, great.
Because the individual's qualifications does not change, kadandi. Except experience, the education qualifications does not change, kada. If it's a pure education evaluation, it's valid indefinitely.
Okay. And normally how much it costs if an employee has to do?
If it's a pure education evaluation, it all depends upon the evaluating agencies. They may vary from $75 to $150.
Okay, great.
Yeah, last question, Bhanu garu, from
Hello,
Yeah,
sir. Are you able to hear me now?
Yeah.
yeah, Durga garu, yeah. మీ క్వశ్చన్ ఎడ్యుకేషన్ గురించే కదండి అడిగారు రత్నాకర్ గారు. Do you have any?
Yeah, small extension, sir. Actually, so since like I have done diploma, and later I have completed distance education degree and PG level. So in that case, like, is it possible to like evaluation, education evaluation, like going to be complete? Is there any RFCs will fail or something like
But I
that?
have to see your qualifications and I have to see your distance education degree, whether it is considered to be valid degree or not, whether it's from the accredited university or not. So a lot of things are there here. Very
So
important.
will they evaluate based on the PG, or will they evaluate on based on the diploma, sir? In that
They
case,
evaluate everything.
evaluate.
Your
Okay.
diploma, your PG, everything they will evaluate. And based upon that, they will see whether you have enough qualifications or not for the position which they want to file for it. That's why it's called education and experience evaluation. These evaluations will be a little bit expensive.
Okay. In that case, like, will they consider any experience will be consideration? So
But they will look into, I mean, we as an employer, we as an attorney, we look into that aspect. If you don't qualify through the education, then we look into see whether you qualify through combination of education and experience. And that's how we
Oh.
try to get the evaluations. It all depends upon individuals. And also experience has to be progressive in nature. Okay. And
Okay.
so there are a lot of things which we look into. It's probably not appropriate forum to discuss in detail. I mean, it's impossible. I can actually do one complete session on that.
Oh,
Hello.
okay. When we, sir, yeah, please, yeah,
Well,
I will follow that.
if you have further questions, Durga garu, I think okay, you can connect offline to Bhanu garu. Bhanu garu will
Thanks a
help.
lot, Bhanu garu. Yeah.
Thank you, Durga garu.
Yeah,
I think,
Venkat garu, one quick question అండి భాను గారికి. భాను గారు.
Yeah, I'm listening, sir.
Yeah. So one quick question అండి. Actually, one of our community members raised a question. Her I-97 is valid till 2025. But she got the stamping till the next month only based on the passport expiry.
Sorry, sir, can you repeat it one more time?
Her I-97, okay. Bhagya garu, proceed.
Thank you, Andy.
Yeah.
My I-797 is approved till 2025 July. I visited India and I traveled via Itihas. I have a old passport and I have a new passport, but they didn't stamp that time. So when I check I-94, I still have a old passport I-94 that is valid until my visa approved, that is 2024. So I-797 approval date is not there.
Go to the CBP deferred inspections and get it corrected.
Okay. Is it like extension or?
I had the same situation actually. I did the same thing. We have to go to the airport and you can get it.
There are two things you can do under this situation, under these circumstances. Please listen to me carefully. Please listen rather than diverting here and there. There are two steps which you can take here. One is you can try to go to the CBP office, CBP deferred inspections office. That means to the airport from where you have come into this country, and go to that airport, go to their Customs and Border Protection office over there and tell them that they have erroneously issued the I-94. They should have correctly issued the I-94 to the date your H1B validity is there, especially provided you have a valid passport until that date. Okay? If you do not have a valid passport until that date, they're going to issue the I-94 only till the date your passport is valid. Okay? And that is one step you can do. If not, if that is not a possibility for you, then you can file an extension prior to the expiration of your I-94. That is, when is your I-94 expiring in 2024?
Next month.
Next month means when, ma'am?
March 17th.
So you can file an extension prior to that.
Okay.
As long as you file an extension prior to that, you're okay.
Okay. Thank you for the clarification.
Extension of an H1B petition. That means your your 797 with your I-94 with 797 is no longer valid. Okay.
Okay. Okay.
Definitely.
Okay.
Thank you.
Thank you, Bhanu garu. I think this is the last question of the day, sir. Okay. Ravi garu, please go ahead, sir.
Yeah, hi guys. This is Ravindra Reda, and I have 13 plus years of experience in full stack AWS and SOA integration, and I worked on big companies like Oracle and JP Morgan. So I need to I'm looking for good sponsor for
No, I
H1B.
think there's a difference, sir. Okay. We have employers, I think. Okay. It's not for Bhanu garu. Yeah. Ravi garu, okay. Message me in the group, Andy. I will provide the employer details, okay, in shortly. Bhanu garu, last question, sir, from one of our committee member. Sir, is this EB2 NIW, right? National Interest Waiver. What is the advantage of, sir, by regular EB2 and NIW category?
Two things. For NAW EB2, you don't need an employer to sponsor you I-140. First thing is that is important. And second thing is you don't have to go through the labor test process. That means you don't have to go through the perm recruitment, perm processing, and all those things. Especially if you're in the 5th year and your H1B, you're exhausting your 6 years, and your employer is not filing your labor certification on a timely basis, and you can't get your H1B extension beyond 6 years normally, then considering the filing the I-140 national interest waiver is very, very useful. And also USCIS is encouraging these days NAW I-140s for the STEM degree holders. Okay, and we have seen recently a lot of NAW I-140 approvals for the STEM degree holders, especially when they have done significant contributions to the STEM degree. Like they have a journals, academia, media, notoriety gaining and everything in the STEM degree fields. We are able to get their I-140 approval, showing that their contributions to the STEM degree field is in the interest of the United States and able to get the NAW approvals in that way. They're a little bit lenient for the NAWs for the STEM degree holders these days.
Okay, sir, extension that for the priority date, right? If you have employer file NIW category, there is any advantage compared to regular EB2 or the same thing?
Same thing. Priority date will remain the same. But point is, you don't even have to have an employer to file an NAW I-140. That's what I'm saying. If an employer is not filing for you, then you should see whether you can qualify, whether you can file NAW I-140, so that at least you can secure your priority date and you're in the line.
Yeah, basically some of the companies for the, especially from EV industry, they are filing NIW, sir. Okay, employers also.
Yeah, but I've seen recently Google, Apple, these companies stopped filing perm applications. They're telling clearly their employees they're not going to process perm and green cards for them. Facebook also is one of them. And there's a reason why Facebook and Apple is doing, because they've been bombarded with the lawsuits, with the Department of Labor investigations, and they ended up settling with 25 million each. But Google, because of that, Google, Amazon, these people stopped filing perm applications these days. There are several Google employees, Amazon employees, these Fortune 500 big company employees are coming to us and asking us what they can do, because they're already in the 5th year, they're exhausting their 6 years in next 4 months, 5 months, 6 months.
Okay, got it.
And under those circumstances for them, the best option is NAW I-140, provided they can establish that the job which they're doing or the intent to work in the field of endeavor is in the interest of the United States, is in the best interest of the United States. Hello?
Yeah. Thank you, Bhanu garu. Om garu. Sir, already.
Yeah, thank you, Srinivas garu. Thank you, all the volunteers. Thank you, Bhanu garu. I would like one of our member, Bhanu garu. I know you want to, maybe you can conclude it, but one of our member will say word of thanks. Satya Dasari or Kishore, Kiran, anyone. Please speak, guys. This is a great opportunity.
Yeah, hi Om garu. Hi
తెలుగులో
Bhanu garu.
మాట్లాడు, పర్వాలేదు, తెలుగులో మాట్లాడు, తెలుగులో
Yeah,
అందరూ
yeah.
ఉన్నారు.
Hi Bhanu garu. Thank you so much for your time and efforts. This is really amazing call. So we gain a lot of knowledge from you, and yeah, thank you so much for your time, sir.
Thank you very
Bhanu
much,
garu,
sir. Thank
2
you,
hours
everyone.
is a very valuable time. Bhanu garu, 2 hours is a very valuable time. You know, it means a lot for Atmiya community. I know a lot
it's
of
my
people have
pleasure,
more
sir.
questions. You can reach out to Bhanu garu directly. Atmiya will publish his contact information. Bhanu garu, maybe you can give a find how people can reach out to you and everything.
No,
Thank you.
already provided Om garu. I'm reposting the information Andi, for Bhanu garu in the chat. Okay.
Bhanu garu, give a lot of word of thanks. Bhanu garu, maybe last one. Sorry to.
Yeah.
Maybe you want to add anything?
Thank you very much for everyone, and
Thank you.
really appreciate giving this opportunity to me, Andy. As Om garu said, one more time, I'm giving my information, Andy. You can reach me through my mobile number, which is 319-400-0053. My email ID is bhanu@bbilawgroup.com. My office number is 703-496-7722. Anytime you can reach me, Andy. I'm one call away and one text message away. Om garu knows about it. I will never miss them. Even if I miss them, I'll get back to them, and I will make sure that they get their answers and everything done. And if I don't answer your call, text me. Text me saying that your name, that you're from Atmiya. That's enough for me. I'll make sure that somebody will respond to you from either myself or my staff members, and will be able to assist you with whatever is needed for you. And I'm always thankful for Atmiya family, and a lot of you guys have been encouraging me and supporting me, and I really appreciate it and really thankful for that. And this platform is amazing, Andy. I've seen in the past 2 years how Atmiya has grown in the country with 9 chapters right now. It's amazing to see this. Once again, thanks for conducting this useful session at the right time, Andy. Entire immigration team, Om garu, everyone, and you all have a wonderful weekend. God bless you all.
Thank you very much, Andy. Thank you,
Bhanu
Bhanu
garu.
garu.
Thank you so
All the
much.
members, Bhanu garu, we are having the ABC conference, Atmiya Business Conference. You have to become a sponsor. I will reach out to you. Our president, Vijayaram Sethi, and the board chair.
Contributing and supporting our friends and community members. Really appreciate all our employees, and I hope every employer has been already registered as an Atmiya member. If not, then please approach our team so that we can help accordingly for your registration. And one more thing, Andy, for our community members, already the currently the market is down, so you have to improve your skills and approach our employees for any help for H1B or maybe their jobs, so that that would help you quickly to settle the job. Okay, so thank you, sir. Om garu, there are around 50 employees, Andy, so probably we cannot go ahead one by one, but we have to say thanks to everybody. So if anybody is not registered, please approach us. Thank you, Andy.
Sir, Venkat garu, small question, sir. And
Sure.
is there any support in Australia as well? Like, do we have any like a work permits, any kind of those kind of visas? Can we support from our organization?
Sorry, ఏంటండి ఆస్ట్రేలియా
Is there any like a work permits, like a support from our Atmiya?
No, you want to migrate to Australia? నా క్వశ్చన్ ఏంటంటే మీరు ఆస్ట్రేలియాకి వెళ్దాం అనుకుంటున్నారా?
Yes, sir.
సార్, మీరు ఆత్మీయ ఇండియా గ్రూప్ లో జాయిన్ అవ్వండి. మీకు అమ్మ శశాంక్ పోషేమ ఆత్మీయ ఆస్ట్రేలియా గ్రూప్ ఉంది, ఆత్మీయ న్యూజిలాండ్ గ్రూప్ ఉంది, ఆత్మీయ గల్ఫ్ గ్రూప్ ఉంది. మిమ్మల్ని అందరినీ మీకు కనెక్ట్ చేస్తాము, రైట్ ఎంప్లాయర్స్ ని. మీరు ఆత్మీయ ఇండియా గ్రూప్ లో జాయిన్ అవ్వండి. కమ్యూనిటీ మెంబర్షిప్ తీసుకోండి. ఆత్మీయ ఇండియా గ్రూప్ లో జాయిన్ అవ్వండి. Definitely we can connect with Atmiya employers in Australia. Okay, or consultancy who can sponsor for you.
Oh, great.
Okay,
yeah, okay, sir.
Yeah, I think it's a time to
yeah, Venkat garu, sorry, conclude చేశాను అయిపోయింది.
Yeah, it's about 11 o'clock. Thank you, guys. Thank you, everybody. Thank you, Om garu, for all the coordinations and everything. All the team members. Thank you very much. And We'll see in the next session. Thank you. Bye.
Yeah.
Sure.
Great call, great coordination. Really appreciate. 2 hours is not an easy. Sorry, Friday, all the volunteers. It's sorry to keep you wait for 2 hours, volunteers. Thank you very much.
Time that way.
ఓంగారు రాజు అండి ఇక్కడ.
రాజు గారు చెప్పండి.
ఓం గారు అసలు ఎంత నాలెడ్జబుల్ పర్సన్ తీసుకొచ్చారంటే ఉన్న 2 hours కాదండి, అది 3 hours అయినా వచ్చిన వాళ్ళందరికీ కూడా చాలా ఇన్ఫర్మేషన్ దొరికింది దీంట్లో, కొత్త వాళ్ళకి పాత వాళ్ళకి కూడా. నేను ఐఎమ్ ఫీలింగ్ అనమాట, అరే నాకు సరైన లాయర్ దొరకలేదు అప్పట్లో.
It's my personal experience. Bhanu garu is very, very knowledgeable, and every rule he need not to look into the books. It's there in his mind. As soon as he sees your case, he says whether it is going to be successful or not.
He
that
has
kind of
very good knowledge, and also he has a lot of patience to answer the questions.
సార్ మన ఆత్మీయ కమ్యూనిటీ స్పెషల్ అవ్వండి ఆయనకి.
I don't know about the discount that he can provide as Atmiya.
ఉందండి సార్, మీరు వెంకట అడగాలి, ఆయన అడుగుతా కంపల్సరీ మీరు అడగాలి. నువ్వు అంటే ఎంప్లాయర్స్ కి ఇస్తా కానీ ఎంప్లాయర్స్ కి ఇస్తా నాకు తెలియదు. అంటే ఎంప్లాయర్స్ కి నా వేడేసు
ఈ గ్రూప్ లో ఉన్న పెద్దలు మేబీ కొంచెం అడిగితే ఆయన డిస్కౌంట్స్ ఇస్తారేమో, సో దట్ అందరూ ఆయన దగ్గరికి వెళ్తారండి.
ఏంటి ఎంప్లాయర్స్ కి
ఇద్దరికి